Welcome to episode 2 of Regulatory Ramblings with Ron Yu and Fred Chan. In an earlier discussion with Bill Miker, we were talking about AI in the field of compliance and how, certainly when it comes to financial crime, it's not inconceivable that on a certain level, you will see redundancies at banks because the day is coming where you may well just have a data scientist running your AML financial crime compliance, that managing the data and understanding deviations matters more than perhaps actual substantive AML KYC sanctions knowledge. And that at the lower level, you're going to see a certain number of junior analysts, ML money laundering reporting officers, middle management, they will lose their jobs. Of course, every algorithm works until it doesn't. So the situation now is there is software that can brief a case, extract the basic facts, the holding, the briefs that, the canned commercial briefs many of us used to buy in law school if we didn't have time to read the entire case in our textbooks. You have software that can produce those now. It's not perfect, but the software is being refined with each passing year. You also have software that can compose memos, legal memos. So, with that in mind, is the legal profession in peril?
Well, yes and no. Okay. No, let's go back to the smart contracts and all the things we were talking about in the last, how many minutes? Smart contracts and AI have made the legal problems that could result far more complicated and far more, and you'd have to think through a lot of these issues far more carefully than what you might have done before. Let's say if it was a simple infringement case, you just look at the two pictures and go, oh, that's simple. Yeah, that's easy. That's infringement. But going back to what I said about analyzing infringement of the two images on a token, okay, you have to now think of the three possibilities, correct? Okay, that requires a little bit more sophistication than, saying, okay, just look at these two pictures, are they the same? All right, you have to think of the three possibilities. So in other words, if you are a lawyer who can actually think through the more possibilities, then you're going to have work, because these are going to be more complicated problems that you're dealing with. If you're going to stay at the lower levels, which are more at risk of being automated, then you're going to have problems. But it's like any kind of profession. I mean, you think about, let's say the manufacturing profession. At one point, you could go in there and, fairly unskilled labor, and you could build some widget. Now, for a lot of factories, you basically, to get in, you have to have some limited university capability, okay, whether it's at a community, advanced community college or whatever, because some of these machines are not simple to operate.
No, we're past the point of where a plastic flower salesman can become one of the wealthiest men on earth.
Yes.
Yeah.
Yes. So, but maybe he could sell NFTs with plastic flowers and become one of the wealthiest crypto guys on earth.
Yeah. Good book. Worth checking out, Asian Godfathers by Joe Studwell on that point. But what you're saying about the low-level work in a law firm, I mean, I've known people that were perfectly content just drafting contracts, and they made comfortable livings as lawyers doing that. Of course, they didn't make as much as the litigators in the firms, but they were content doing that. And then you'd have the consultants, you'd have the people who were of counsel to the firm, and they would be paid, a certain amount, a certain, salary, or, retainer fee, or, on project basis, they may be recompensed for their subject matter expertise. So I see a role for people like that. But it sounds like you're saying the guys that are drafting contracts, their jobs are on the chopping block.
if you have automation that can do a lot of what they're doing now, and this is true
So
with
it would seem.
yeah, this is true. No, it's just a matter of economics. Okay, it's a bit like the argument people give against the minimum wage. It's like they say, well, if the minimum wage goes to a certain level, McDonald's would just replace all its counter staff with iPads. Okay, for example. Now, if you
And they've
have
done that, even in
no,
even in
they're doing it.
developing
Yeah,
markets.
they're doing that
Yeah.
now. So at some point, if the economics, if the systems become good enough and the economics are there, um, this is a real risk to those people. I mean, but then you look at the other professions like journalism. You've got journalists writing, short stories for example, with sports reporting. A lot of it's now written
Sport
by
reporting,
AI.
stock
Reporting, it's all
reports.
done
Yeah,
by AI.
yeah.
Yeah.
Where it's data intensive,
Okay.
that can very easily be done.
By AI.
Right.
But the really good, for example, investigative journalists cannot be replaced by AI.
Yeah. Yeah, I mean, I'd say that, but here we come into a problem in publishing, that the market for long form journalism and the publishers that are willing to foot the bill for it and let you go out on a limb for several months on a story, that I don't think that other than a handful of news organizations in this world, I don't think that that's really possible. I mean, now it's like, how much did you produce in a given day, in a given week, in a given month? How long were those stories? How many people did you interview? How long was the story? How many hits, more than anything? How many hits did your story get?
But has that evolved into a different format, like this podcast? Okay, this podcast might have been done a couple of years ago as a long form article or several long form articles. Now you're doing a podcast for however much time is needed. It's a long form. It's a very different type of environment, but it is long form journalism, if you will, in this case.
My sense from talking to lawyers in this town is the key question of the 21st century is going to be, how well do you work with technology, and how well does your labor and your knowledge and your insight and experience, does it complement the output of that technology? And if the answer is in the affirmative, then you've got a role. If not, I don't know. It seems like there are going to be a lot of unemployed LLBs and JDs in the short to medium term.
Sorry, part of the complication is that in addition to the technology, they are now going to, depending on the area that they go into, of course, they are going to have to also deal with the industry dynamics. Let's go to fintech, for example. You think about fintech, let's say 3 or 4 years ago, nobody was talking about decentralized finance. And then all of a sudden, within a year, they're talking about DeFi. And then they're talking about NFTs. Then they're talking about the crash of Luna. Okay, these are very, very difficult areas to try to wrap your head around. Even if you're just trying to observe the industry as a remote bystander, it's not easy. Okay, because you have a lot of concepts that you now have to suddenly understand and perhaps internalize just to talk to your clients, for example.
And oftentimes regulators feel like they're groping in the dark, but yeah.
Yeah, and you're right. Most of them, that's the client will ask. I mean, I guess if you speak to a lawyer nowadays, say in a day, say 20 questions from a client, any client, maybe nowadays half of them or more than half of them are NFT related or blockchain related or crypto related. So it seems like you don't have a choice, really. You do really need to keep up. And it's tough. I mean, I'm a cyber forensics cybersecurity forensic, in that line of work, and I could easily spend the whole morning just browsing through my LinkedIn update, technical update, just try to catch up the headlines.
My feeling, and this is something else lawyers have said to me, the danger is, this is a growing field. They're hungry for expertise. And the concern is that because it's a new field, you have people that will take certain certifications in this area, and some are better than others. But these certifications are a starting point. There's no substitute for on-the-job experience.
No, you're right.
Yes.
But these certifications are seen as a proxy for experience, and they're getting hired.
You're right. I mean, it's back to the juicy bit you're talking about, right? Just like in the DeFi world, there are new protocol with high returns popping up every week or every other day, right? So it sounds good, but is it real? I put my crypto investment into all or nothing category, meaning so that's why to reduce my time of monitoring the risk profile, because it's just so much, right? And for that collapse, I mean, I actually seen some warning popped up in around March, April time about that, saying that it's a Ponzi scheme and whatnot, but in particular targeting the anchor APY, right? So the question is, how would a protocol come up with 19.5% return APY? And to be honest with you, in DeFi, well, that's nothing. I've seen staking protocol offering 70%, even over 100% yield APY. So from that perspective, that's why I put it into all or nothing category, because it's not really, high risk, and also I didn't put in a huge amount, and then so I just let it sit there, and also I'm testing, the concept of using a fund to protect the pact. And it turns out, it didn't work because of various reasons, right? So, sorry, yeah. So it's hard to play catch up, really, and you just have to do the walkthrough to really understand the real meaning from all this juicy bit you picked up from the news headline.
And to answer your other question about lawyers, they have to learn how to actually ask the right questions. Okay, I got this insight from a friend of ours who's a lawyer.
With regards to technology or with regards to doing investigations?
Kind of more the technology, but also with the investigations. First off, you have to know how to ask the right questions, because the people, I taught a class of designers recently, and the first class they asked all sorts of questions, but it was very clear to me that they were mixing up, in this case it was an IP class, they were mixing up trademarks and patents and copyrights, and so they'd ask me, can you tell me about
Well, there is overlap there, right?
Well, no, they were asking questions like, can you tell me how why a trademark lasts 20 years? I go, what? Something like that. And no, I mean, first you have to recognize how to ask the right questions of the people, or if they've got misconceptions, how to correct those. Some of it goes to definitions, as we spoke of earlier. But like, as I said with my friend, our friend Mike, who's a lawyer in New York, he was explaining in a recent Twitter space, a lot of the questions he has with his NFT-related clients really are licensing issues, and you have to be able to actually recognize the issue, under what all that these people will give you a lot of stuff to think about, but at the bottom of it, at the end of the day, it was really just a licensing matter. Okay, but you have to.
Rather than, oh my God, it's technology. What do I do?
Yeah, but you have to be able to sift through all that to understand that the problem is not the technology; it's the licensing. For example, okay, it's not the technology, but it's your the way you wrote the contract, for services or service development. it's just trying to recognize, going back to what you had said earlier, it's trying to recognize a basic legal problem. But because it's couched in all this technology and this technobabble, you have to sift through it. And because there are also these industry related changes and jargon that might also be obfuscating matters further, you also have to sift through that. Okay.
It can be very dense, and it can be, I mean, just when one thinks of the bar exam, for example, and the long interrogatories, the long fact patterns that you get, and you're wondering what exactly is being asked, and someone with true insight would see, okay, no, this isn't really a technology problem. This is a licensing issue. I guess if you know the law well enough, the issues will leap out at you. That's one way of looking at it. But I think, again, this isn't just about black letter law. It's about practical experience. And many lawyers lack the experience in dealing with novel, cutting-edge problems. Either that, or they don't want to touch. There are certain cases, there are certain files they don't want to touch it. They pass the buck, they pass it on because they want the easy cases, the low-hanging fruit. They want to get back. They want to leave by a certain hour. I mean, some of these cases are a first impression that they're involved. And I'll be chastised for this because many lawyers will say, no, I'm pretty tech savvy. I add value. I get the feeling they're fearful of technology. They run away from it. Okay. They outsource a lot of this stuff to outside firms to deal with precisely because they're uncomfortable with technology.
I think comfort with technology is really a lot.
And I'm not just talking about using a computer and using the smartphones.
No. I agree. I agree. There are a lot of people who would say that, let's say the younger generation, they grow up with technology, they're tech savvy. I would disagree that they are tech savvy in the application and use of technology. They may not necessarily
in the consumer sphere.
But they may not necessarily be tech savvy in the underlying. When you look under the hood, shall we say? Now, in terms of lawyers and technophobia. You do have some lawyers and judges who are tech savvy. I think Justice Alsop, who did the Google and Oracle at first instance in America, he was a part-time programmer, more of an amateur programmer. If I am not mistaken, Justice Colin Burse of the UK has a software background. He's also a tech fan, Star Trek fan, and then Justice Wei, George Wei in Singapore has a tech background, although that is in biotech, if I'm not mistaken, not software. But the fact is, but then you also have other people. Judge Randall Rader of the formerly the head of the Court of Appeals Federal Circuit. He was one of the most influential patent judges of all time. I mean, he came up with his the way of looking at the
CAFC.
CAFC, yeah, okay. Yeah. I mean, he came up with some very, very influential concepts. His degree, if I'm not mistaken, his degree was in English. He was an English major at start. So I do think there's and he's gone from that to one of the world's leaders in advanced networking, specifically 5G, FRAND licensing, okay? So the fact that you have, I think if people want to get into this space, they have to check their technophobia at the door.
I think I agree with the implicit point you're trying to make, which is someone through reading and enough research can come up to speed.
Or recognizing where their limitations are. That's
precisely.
Also, yeah.
And if anything, a law degree and 2 LLMs later, I mean, if anything, that taught me how little I know. But yeah, I mean, knowledge of your own limitations is also important, because many people lack that. Yes, a person can come up to speed, but I query whether or not there's a substitute for that practical experience, because I think certainly in my law school, there were people who may have had liberal arts backgrounds like myself, and oftentimes you went to law school to avoid numbers until you start seeing federal income tax questions on the bar exam. Then people start freaking out. But or on wills and trusts, that's another one where they get you. There were people who went back to night school to get the bachelor's degree in computer science or hard science, just so that they could sit for the patent bar. It's easier for someone who has the technical knowledge to learn about law and business. It's tougher to do it the other way around, though. In my view, it can be done, but it's much tougher.
I happen to teach a class. One of the things that we have learned is that if you actually present law to them and the analysis mechanism process in terms engineers can understand, most of them can do a pretty good job of analysis. Okay, it is not unlike the scientific method for proving a hypothesis. You have a hypothesis, you grab the facts, you do the analysis, and you come up to some kind of conclusion based on the analysis. Now, if you think about doing, some analysis of legal problems, the FIRAC analysis, fact issues, etc., you find out you can actually do a lot of the same. You can actually map one process to the other. I mean, I'll give you an example. In our class, I actually showed them how you could use the scientific method to analyze a legal problem, and then I showed them how they could actually use FIRAC to analyze a problem of aerodynamics. And given they're engineers, they probably freak out when they see a law guy talking about aerodynamics and aerodynamic theory and coefficients of drag.
This is a valid point. You know why? Because when many of us start in law school, we buy many study aids. And oftentimes they're covering, you may buy 5 or 6 different study aids for contracts. They're covering the same subject matter, but the information is presented differently. In one case, it may be in flowchart form. In another case, it's in narrative. Other case, it's in outline form. And I'm old-fashioned. For me, listening, taking notes, then crafting your outline accordingly based on topics works. But I can see where contract law broken down into flowcharts would work for an engineer, yes, or a systems analyst, or someone who thinks in that.
You can also do that for criminal law. If I'm not mistaken, Professor Amanda Whitford has done that with her law books.
And it's been done with evidence,
Yes.
in the U.S.
Yes.
401, 402, 403 is evidence relevant?
Yep.
Is it, is there hearsay? Is it barred? And if it's not barred by that or any other rule, is the risk of prejudice outweighed by the risk, the value, the probative value?
Or if you're using securities law in the Howey test, right? You have
investment contracts, yeah.
Four-pronged test, right?
Yeah.
Is it is exchange of in money or value? Is there a common enterprise? Is there expectation of profit? And is this profit derived from the efforts of a third party or promoter? Okay, so you actually have that 4-part flow chart you can go through. It and I bring that up because that's actually a big deal with NFTs. Aside from IP, securities risk is another area that a lot of NFTs raise. In fact, you have a case in the U.S. with who is it? Who is that case? You're the Board 8. No, not Board 8. Dapper Labs. Dapper Labs there's a class action lawsuit on against Dapper Labs because people were upset that they were not allowed to sell their NBA Top Shot.
Was this in evidence? The Dalbert Fry standard?
No, this
No.
was actually no. This is actually under securities law,
Okay.
and they because Dapper Labs had minted. I think they had minted these using the Flow their Flow blockchain, not Ethereum, but Flow blockchain, and the parties alleged that because Dapper Labs was responsible for for promoting the NBA Top Shot and thus was responsible for its the rise in value or fall in value, this in fact was a de facto security because there was really no challenge to the first 3 points of the Howey test. Okay, it was a joint enterprise. People were buying these because they expected them to go up in value, and they were paying money or crypto for this. So they were looking at the fourth prong. It's like so you have to ask your
efforts of others.
Correct.
But the Howey test is the great catch-all of things you otherwise wouldn't think or securities get caught under the Howey test. Because, again, if we're looking at process, it's is it a security based on the SEC's list? Stock, debentures, debt, bonds, what have you. But if it's not on the list, does it meet the Howey test? And if it meets the Howey test, then it's a security.
This was also done, if I'm not mistaken, this was also done in the case of IP Exchange several years ago called IPXI. And what they had tried to do was essentially provide a exchange of standards, essential patents, basically commoditizing them. And they were using essentially a proto-crypto token, which they called a ULR, Uniform Licensing Resource. I think that's what it was. But anyhow, the SEC claimed that because this ULR was also, fluctuating in value, and because it was dependent on how IPXI was, promoting their platform and thus the, and the technologies in the platform, this was in fact a security and of sorts. So this is actually, so what's happening with Dapper Labs has also happened in IPXI, and I bring that up because you have now people using exchanges using NFTs for the exchange of intellectual property rights. Okay, and so since IPXI was doing exchanges of intellectual property rights and using essentially a token, a crypto, this is now a question people are going to have to think about when putting up exchanges like this. And this goes back to the lawyers. Are they smart enough to think that when you put up something, you do an exchange and you do the exchange of value in the form of a token? Are we doing a securities? Okay, an IP lawyer may not think of securities law. I mean, to be fair,
but the law truly is a seamless web, and you have to.
Okay,
we're in an age of specialization.
Correct.
But to some extent, you have to be a generalist.
Correct. But then also, going back, if you had brought this IP exchange question with NFTs to a securities lawyer, they would not necessarily, to be fair to them, you should not expect them to think of the IP-related issues, which would be licensing, which should be whether they're proper assignments and transfers recorded. All sorts of other issues that are IP related that a securities lawyer, to be fair, should not be expected to answer. But that's the problem. People will go up to these lawyers and say, I want one answer for everything. And in fact, this is not a single answer. I mean, it's not a single practice area type of answer. That's why going back to what we started with the risk mapping. It's not that simple to map. Okay, it's not. When you do IP and NFTs, for example, it's not necessarily just infringement. It's not just IP. You may have, depending on what you're doing, you may have securities issues. If it's a token that's attached in some way to a particular individual, you have privacy issues. Okay, I mean, with the security law, I know to think about privacy issues with an NFT. I don't know.
Again, we're living in the age of the specialist. It's no longer, your town, county, squire type lawyer who served the community, and they were exposed to a little bit of everything: criminal, family law, contracts, commercial disputes. So I think that's a consequence of that.
The other
And
consequence,
different practices can be kind of siloed. So, I mean, yeah, there's some cases where people work together in the firm, but
there are other instances where you have to also consider where the parties, the influencing parties are. Let me give you an example. Let's say you and I were designing an app, for lawyers, for whatever reason, we want to put it under, I don't know, put it on the App Store and the Google Play Store, right? You have to follow the rules that are set by Google and Apple, and they have certain rules for privacy. So in fact, the privacy policy may not be really dictated by you, but it may actually be dictated by these other parties. You also have to consider that possibility when you're putting out these contracts or whatever. You have other parties that are going to have some influence in what you're doing.
true. Because they set the default rules.
Correct.
I remember coming back from an event at Cyberport. The government was doing some Fintech Sandbox event back in 2016, 17. We were coming back from the event at Cyberport, and it was you just had to keep track of how often people would use the right terms of art, the right buzzwords. Proof of work, proof of concept, blockchain, distributed ledger technology, cryptocurrency. I mean, in DeFi, I mean, it's like, it's to the point where you would go to compliance conferences sometimes, and you would hear the same buzzwords, and people would start to become numb to them, like, how do we encourage a good governance society, good governance culture? Tone at the top. I mean, you hear it so often, it becomes like a cliche. And then people stop tuning in. And that's how it is with a lot of people. It's like so much white noise. And I'll tell you something else. Crypto really hasn't caught on, I don't think, with Hong Kongers. Or even people in APAC, not the way stock markets are gambling, show far more appreciation.
Your turn. Go let you do
I
this.
totally agree. Why? Because I guess because the learning curve is so steep, very steep, and I don't know. I mean, I talk about how I to spend the morning browsing through updates, and again, it takes a lot of time, and it also means you have to be open to any possibilities. All right. So when you grow, when you age, then you start to get stubborn and you stick to your own value. All right. In Hong Kong, for example, like you've seen all those crypto advert or NFT advert, right? I always curious about, and then it says, check out the group in WhatsApp. That's Hong Kong, right? But if you're into that space, then you know the usual, like Discord, maybe Twitter, rather than the W ecosystem we got here. I guess it's depends on the person, whether that person is willing to explore new concept, new technology, really want to give it a try. So that's how I spend my, that's how I put together my crypto investment. To be honest with you, it's just for me to set aside a small amount to walk through the process, walk through, all this DeFi.
So you're treating it as a learning.
You have to, because like swap, for example, right? I mean, Is it the same kind of swap we've seen in the traditional financial instrument? It's pretty much the same. But again, not until you walk through the process to realize, yes, that the APY they pushed out, it looks sexy, but again, when it comes down to reality, then every bit you lose every bit of the money throughout the process, right? Why? Because that's how the protocol make money, the transaction cost and the spread and the slippage or whatever, right? It's part of the cost, right? So you have to walk through it, and then you realize, okay, this is what it is, all right? I mean, Hong Kong, I don't know. I mean, it just, a lot of people talk about crypto and NFT, but are they really talking about the same thing?
Yeah. No, people will conflate a lot of things together. I mean, and so you have to also understand that there's a lot of conflation, whether good or bad. That's just the reality. Like, for example, when Luna dropped, people were saying that's going to affect the NFTs. And then the crypto guys said, with some justification, these are two separate markets. And I said, yeah, that's true. They're two separate markets. But to a lot of people, crypto and NFTs are the same thing.
Yes and no on that, because there's
because it's the underlying blockchain technology.
Yes and no. The way I say it is the spillover effect. All right, because yes, Luna itself is just a crypto, but also in the bigger scheme of things, you've got Bitcoin, you've got Ethereum. All right, it goes back down to like the financial crisis we went through in the 97 or 2008. All right, it's the confidence that drives people to make the decision.
Right.
So yes, Luna is one side, but does it mean Bitcoin is safe or Ether is safe? You don't know. It's hard to tell.
But that comes back to the point of confidence. The man on the street may have dropped out of high school in Form 5 and opened a Dai Pai Dong, and he will blindly put money, well, at least once upon a time before the 2008 crisis, would blindly put money in HSBC or Hong Kong Electric or Hang Seng Bank or Chung Kong or any
CCW.
Yeah, any of your blue chip Hong Kong stocks, they would blindly put money in that. They don't have that confidence in crypto. Many older people think it's a scam. Their attitude is, if I need that level of privacy, I'll use cash. And I will tell you this, that there is I was telling Bill Miker about this when I spoke to him, that there is a cadre of former Royal Hong Kong police force inspectors, senior, many reached the level of assistant commissioner. In retirement, they found jobs in security, investigations, and compliance at major banks in Singapore and Hong Kong. There's alumni network. Many of these guys were expats. They were Westerners, Brits, New Zealanders, Kiwis. As time passes, they're being, aged out. They're being phased out, as is the normal course of things. People retire. But I recall, by this point, it's almost 10 years ago, 2014, 2015, middle of the last decade, asking them, and many of their attitudes have not changed. But of the dozen people I spoke to, 11 more or less said the same thing to me. What manner of chicanery is this regarding cryptocurrencies? What manner of chicanery is this? Why does the average person need this level of privacy? And they seem, again, 11 of the 12 were of the view, and the 12th guy had a technical background, computer science background, so he was more open-minded. But the rest were of the view that it's a scam, it's a fraud, it's a portal for money laundering. And again, they're coming at it with a copper's perspective. They're putting on the blinders. And they're saying to themselves, again, why does the average person need this level of privacy? And their attitude is everyone's guilty until you prove your innocence to me. Why? I mean, I find that attitude very prevalent amongst law enforcement and certainly many regulators, and certainly the position the HKMA has been these are not cryptocurrencies, these are digital commodities, and you trade them at your own peril. But what do you suppose it is about law enforcement that why are they so suspicious of it? Why are they so averse to it? Or is it doesn't fit in the normal paradigm, the old paradigm of fiat currency you could control. They coppers can't, the police can't operate in an environment where they have no control.
I think, first off, if you're in law for enforcement and you actually understand blockchain and its implications, you would realize that blockchain, a lot of the cryptos are not necessarily ideal platforms, for example, for money laundering. Okay, because let me give you an example. North Korea has been laundering a lot of money, crypto, and they did a lot to hide, they were traceable by the wallets basically, and they knew it. But so they went to a lot of effort to hide the actual ownership of the wallet. But once they found the wallet and could actually reliably tie the wallet to a particular actor in North Korea, then it was actually relatively easy for them to trace the wallet. Now, the next question, of course, is what you do after that. All right. Now, from what I understand is that they did not actually go after the North Koreans because they realized that would have been futile. They let the North Koreans do all the transactions they wanted. But where they got them was they found that they were going through certain exchanges, so they basically put pressure on the exchanges not to allow the transactions to go through. So they prevented them from cashing out their gains. So so the North Koreans are actually forced to go to another venue. But but you see, this was done with by people who are specialized in computer forensics and particularly crypto investigative work. So they would actually understand the implications of the blockchain and why it's not ideal for money laundering. Now, I suspect, since you said that the 12th guy was a computer science person, he probably may have actually understood this and the implications of the blockchain better. Okay, this actually goes back to what we were saying about NFTs and also about lawyers. They have to understand the implications of these technologies, and developers too. I mean, people talk about the blockchain, and they say it's immutable, and they actually don't understand what that means. Okay, I mean, I've seen these people that you're saying, I want to put an insurance application on the blockchain. Oh, that's going to be wonderful. The information's immutable. And I'm saying, yeah, what if you make the wrong, you put in the wrong data? What's going to happen? Oh, we'll change it. I go, yeah, it's immutable. I go, oh, I mean, something like that. They just don't see the implications of it. Okay, I mean, if you're going to say something's not changeable, and then you put information that might need to be changed, you have to think about how you correct something if there's a real problem, and they don't think these things through because they don't connect this. It goes back to what you were saying. They repeat the jargon parrot the jargon mindlessly without actually thinking through the implications.
Ron and Fred, thank you again for joining us for this podcast, and hope to see you guys again soon. Please come back.